oral argument in State of Iowa versus Allison Elaine Dorsey. Counsel, if you're ready, you may proceed.
May it please the court, counsel? We have raised 5 critical issues in our brief. I would like to address 2 of them here. The first being the motion for change of venue filed by the state of Iowa, granted by the district court. The record review is de novo of that motion and its attachments. Iowa Code Section 803.21 states that the jury trial shall be tried in the county where the crime was allegedly occurred, unless there's an exception under the law. That historically derived from the Revolutionary War as a protection for the defendant. British soldiers would capture American soldiers, ship them over to Britain, have the trial there. They were immediately convicted. That's where the legal philosophy was born in the United States of America, filtered down to Iowa's Code Section 803.2 sub 1. Exceptions under the law are under the Iowa Rules of Criminal Procedure 2.11 sub 11. There are no exceptions in this case we submit. The motion uniquely was filed by the state in this case, but the analysis should be exactly the same as if the defendant. It's a high bar to reach. The same high bar should be for the state, which is allowed to file this motion under the law, our opinion is. But our argument is that the decision in this case was premature. The motion was filed in April of 22. Jury trial, second jury trial, was in May of 23, 13 months later. The defense in that case argued for the ability to send out jury questionnaires to see what, if any, effect the first jury trial had on the bias, prejudice, anything like that may prejudice one side or the other. The court didn't allow that, and the court didn't allow it to proceed. As we hear often as defense lawyers, let's see what voir dire says.
Can I interrupt you just from a factual perspective? So that hearing was like in April, and at that time the trial was set in June, is that right? A couple of months later. And then then the court ruled and granted the venue change. Trial was then continued again. Was the venue issue raised again before? I know it was raised like the very first day of the second trial the following May, but was it raised again?
I don't believe it was raised again, no. No, that's correct.
On the point that you were just making, as I read the district court's ruling, the district court seemed to be relying on some of the data maybe gathered from the first trial. Is that appropriate?
That can be used as an analysis by the district court, of course, yeah.
I mean, would it be wrong to say that the district court felt like it didn't need any more info to kind of figure out the level of knowledge that the public might have about this case?
They mentioned the voir dire during the first trial and the trouble they had. The problem I have with that as Ms. Dorsey's attorney is that the jury, this is a murder case, began on October 26th, the first one, of 21. That was when voir dire was. Evidentiary portion of the trial was October 27th. A murder case, the jury was, by all parties' agreement, seated in one day. Okay, that included individual voir dire from the people from Cass County, but they still seated it in one day. If a second jury trial takes a little bit longer, then that's fine. Cass County has 6,000 registered voters in which to draw a jury, and they used 100 of them in the first trial. Okay, that was a point the defense lawyers argued in the motion for change of venue, wanted to deny it. Okay.
This Oxley's question about whether or not the venue issue was raised after the order changing venue. So you have the order changing venue. Is there any motion practice or objection raised after that order was entered?
There was no record made after that point, Your Honor. I believe they relied on the previous hearing.
Under 803.2, the statute says, all objections to venue in the county to which the action is transferred are waived by a defendant unless the defendant objects by a motion for change of venue filed within 5 days after the entry of the order transferring the action and secures a ruling before the panel is sworn, et cetera. So was that done in this case? And if not, how do you overcome the language of the statute?
The motion for change of venue. They had the hearing, and they transferred it to Pottawatomie County, away from Cass County. And the record's not clear. I mean, I didn't try the first case, didn't have the motions. I didn't see it in the record anywhere where it was brought up again for a change of venue back out of Pottawatomie County after the fact. Okay, I believe the record's preserved, though, on the hearing and the evidence that was presented at that hearing.
I agree with that. But if the appropriate record wasn't made under 803(2) sub 3, the statute indicates the challenge is waived at that point. So how would you overcome that statutory language?
Issue initially. I know that what you're saying, the order transferring it to Pottawatomie County, I think the defense lawyers felt they didn't have to re-raise it again at that point.
And there's no constitutional question raised.
Correct. Yeah. The state relies heavily on state versus.
Did the earlier counsel argue for a county other than Pottawatomie if it was in the alternative, if it's going to be transferred out of Cass County? Did they suggest somewhere else, more rural?
Yeah, at the hearing, in the motion itself, the state didn't raise what county they wanted it transferred. They had the oral arguments, and it all happened fairly quickly. And they argued, the state, at that point, let's move it to Pottawatomie County, and they did not raise, the defense did not raise another county at that point in time, no. They were objecting to any other county. That was their mindset. I'd like to point out the State versus Robinson case that the state heavily relies on in this case is easily distinguished. That was a horrible stabbing with an eyewitness, overwhelming guilt of the defendant, and that gory details, along with the eyewitnesses and the overwhelming guilt, proliferated the news in that area, and the defense filed a motion at that point in time, and the court held that there was overwhelming evidence of guilt that had proliferated, sufficient to be so inflammatory a fair and impartial jury could not be sat, which is the standard. Here, there's nothing equivalent. The only record is the motion and the attachments at the change of venue hearing. And look at those attachments. I'll get into that in a second. I divided them up into 3 sections. You have churches and bulletins. You have photos with the defendant and some other people. There's no record of who they even are, but very few people. And then the news media. There's some television accounts and some newspaper articles, but all that is completely benign. It's neutral. I would equate it to a case this court held in 1988 that said the record does not disclose, as the defendant who is appealing would have it, sensational reporting of a routine crime. Rather, there was routine reporting of a sensational crime. That is exactly what we have. If you look closely at those attachments, they're benign. They're neutral. They're asking for prayers for the jury, prayers for wisdom. The news is neutral. It says that there was a hung jury on the first trial, things like that do not raise to.
Neutral is not the first word that comes to mind when I read them, Mr. Hook. I mean, there is certainly there are sentiments for and against the defendant that are an undercurrent in all of these attachments, these social media things. Am I misreading them?
That's a fair statement. It's not a neutral. There's favoritism on one side or the other. I think the words I'm looking for, they're not rising to the level of inflammatory that is required in order for a change of venue in that case. The first trial, of course, ended in a 10-2 hung jury in favor of the defendant.
What's the evidence of that in the record, apart from I saw the one text that indicated that was the vote? But
77-78. It's in the order of November 4th, 2021, following the jury trial. And it's our contention Cass County has absolutely nothing hostile to the state. It's their burden to prove that there is, and it's simply not here in this case. If
that order handy.
Sorry?
Order handy, because I didn't see the order that you just referenced, 77, 78. If you don't, I'm not going to slow you down. Okay.
On our record under the 70s.
And the vote in that order, and so that's what I was following up on.
I did in our brief as well. The standard is in, go ahead, sir.
I want to clarify the standard of review, because it looks like your brief at page 23 says a standard of review for a change of venue in a criminal case is abuse of discretion, but the appellate court reviews the record de novo. That sounds like we're talking apples and oranges.
I have a case that states, this is from the Polillo case, this court in 1976. Our review is a de novo determination of whether the trial court abused its discretion by ruling in substance that Nebinger failed to demonstrate a substantial likelihood he would receive a fair and impartial trial in Scott County. So I think the record, you can look at the attachments de novo, but the abuse of discretion is de novo.
To this thing that Justice May was raising, can you give me again the appendix site where it was in the record that that was actually the split in the jury?
78.
The court's order granting a mistrial, but I don't see any reference to a split in the particular, and I didn't see any indication that the judge polled the jury or anything like that, which normally they're not supposed to do.
Interviews done afterwards by the defense lawyers. That would have been done after that order.
And in the social media posts about the vote? Wasn't there a reference in the social media posts to the vote, to a vote?
In there, and that might have came from the interviews by the attorneys after the verdict.
The standard is abuse of discretion. What specifically did the district court do to abuse its discretion?
I believe factually it determined that these attachments rose to the level of being so inflammatory that the state could not sit a fair and impartial jury in Cass County. And legally, using that standard, legally they determined that a change of venue was warranted. I think that decision, and both on what the attachment said and the decision to move it from Cass County to Pottawatomie County, where 3 of the witnesses for the state worked at the Children's Hospital and advertised in that community. Many of the community use that hospital. And there's 97 other counties that could have been used to move it to where the state's 3 primary witnesses practice medicine.
Oh, sorry. Oh, I was just going to ask if that specific point was challenged by your predecessor.
As far as the specific county, there was no objection made when the Attorney General argued for Pottawatomie County at the hearing. It was right towards the end, and the ruling moving it to Pottawatomie County did not come till.
Then moved to move the venue away from Pottawatomie County.
I want to note the defense raised 2 very good arguments, 3 cases at the motion itself hearing that I'd like to bring to this court's attention. The first was State v. Finn, which is an unpublished opinion decided after the Robinson case. It's pertinent in this case because there was questionnaires sent out. 314 jurors answered. 146 of them were excused for cause. They still didn't move the venue. The court said the importance is placed on the voir dire process. The second was the Nebinger case, which deals with time lapses. It cited passage of over 3 months between the airing of a program and the Nebinger's trial date of May 29th. Our courts have previously stated that similar time lapses were sufficient to dissipate any prejudicial effect that program would have had. And I understand that originally the court was going to be in 2 or 3 months after this hearing. But they didn't allow questionnaires to even go out as requested by the jury, which would, I think, clarify. Is there any bias here amongst the community after the first trial, which is a reasonable, offer by the state, but let's see what it is. There is no information other than the voir dire in the first case, in the first trial. These attachments don't show the bias necessary at all to show a prejudicial effect where you can't seat a fair and impartial jury, especially when the first trial was seated, the jury was seated in one day. The second issue, if I may, I'd like to raise is the verdict itself is not supported by substantial evidence and not supported by the weight of the evidence. I'm combining those, and they have different review standards, I realize. Ms. Dorsey was found guilty of second-degree murder and child endangerment resulting in death. The evidence had to prove in that case, beyond a reasonable doubt, that the defendant inflicted the injury causing the child's death. That was an element of both. Combine those because, as the state alleges in their cases, it's not whether a injury occurred, it's the timing of the injury. The evidence in this case showed Dr. Smith and Dr. Bowen, the defendant's experts, said from autopsy specimens, they conclusively concluded that due to those brain slides, that this injury had to have occurred at least 2 days prior. Okay, but what's important, the state's witnesses, Dr. Cruz, who did the autopsy, and Dr. Hefty, a rebuttal pathologist, most could not exclude that the injury occurred before October 7th, the day the baby was bought. For the first time, the defendant had seen the baby or had any opportunity to handle the baby. Could not exclude that the injury had occurred before. They did not commit to the position that the child must have suffered the fatal injury on that day.
Over time, and I know you'll be coming back for rebuttal.
Thank you, Your Honor, and may it please the court. Counsel, good afternoon. It's a privilege to be here. So I want to start with the record discussion that was had earlier. I also couldn't find where a 10-2 split in, or any split is described in the record, other than there is one social media post that says that it was 10-2 in favor of acquittal. People can say anything on social media. We don't have any statement in the record that establishes that. I didn't see any indication from the mistrial transcript that there was polling done. I've also been unable to confirm. I also don't want to tell you things outside the record. What I can tell you is that the fact, whatever the split may have been, was never argued as a reason not to grant a change of venue.
Struck me is reading portions of the trial transcript. The county attorney indicated as soon as the jury said they were deadlocked for the second time, they got up and said, "This has been a problem. We think the venue should be changed." And the trial judge said, "Go ahead and file a motion. If you want that, you need to file a motion," which tells me that this wasn't a tactical response to the state knowing what the split on the jury is, because I don't think they would have known what the split was right as the jury came back and said they were deadlocked.
About the whole trial and the, this comes back around to the evidence that supported the change of venue ruling. And that evidence not only included the attachments to the motion. At the beginning of the hearing, the court took judicial notice of the transcript from the first attempt at the trial. And that included, the court went through the numbers of how many interviews individual voir dire were conducted and how many people said that they had already formed a fixed opinion of the merits.
So the state moved immediately after the first, or within a couple of weeks after the first trial. And at that time, I think that the new trial was probably scheduled within a couple of months. But then there were some continuances. The motion on the hearing wasn't heard until like April, right?
That's right. And then at that point, trial was scheduled for June, as you said, and then it was continued.
Is any new evidence about whether or not the social media posts were continuing, or was it all still based on the social media and the news accounts from back in November?
There was no attachment other than the one that was filed with the motion to change venue in November. Now, I want to point out that one of the things that's important about Seamers, about Kidd, about Nebinger, is that the reporting was, in those cases, was mostly a burst at the point of arrest and charging that abated by the time the trial rolled around. When the state filed its motion with its attachment, it was pulling news articles and social media posts and prayer bulletins that surrounded the time of the trial.
This church bulletin issue, do we have any sense of how many people actually saw those or got those? Is that in the record at all?
It isn't.
In Cass County or on Facebook, or how many people actually saw these posts that were in Cass County?
Cass County, no. We do have some of the names, which I think align with, no, I don't think there's any record made on use by county.
It seemed really thin to me. And as I read the newspaper articles, it seems pretty vanilla in terms of what it's talking about.
Articles aren't so bad. It's really the charge and the valence within the community about the way that the case is generating posts with as was recognized, that undercurrent that mostly on behalf mostly in support of the defendant, people changing their profile pictures is more than just saying that they're praying for the jury to have wisdom.
What are we talking about, though? I mean, if we're going to take it out of this county, isn't there some critical mass of the population that we can at least know or extrapolate to?
Set a specific percentile threshold out of the 6,000 or so registered voters in Cass County, what percentage of them have to have a fixed opinion of the case or have to be involved in Facebook discourse? I will say that the ultimate standard is there a substantial likelihood that, a substantial likelihood that the court will be unable to draw a jury that can fairly and in an unbiased way try the issues on the evidence to be presented at trial. And another way that...
In this case, they did it in one day, right?
It's not exactly clear that they did. One of the things that happened during trial is that one of the seated jurors was exposed to news coverage that compromised his ability to be impartial and had to be excused during the middle of the trial. The other problem is that the court noted that some people were saying that they didn't know, like their questionnaires indicated that they had no connection to the case, and then some questioning exposed that in fact they did have a fixed opinion of the merits. And so it's not those people were right.
The jury that actually was sat at the first trial was biased.
We don't have any evidence supporting any juror misconduct or inherent bias.
Just that there's a mistrial that then the state gets to move the second trial out of the county?
No, and I don't think that the mistrial itself is the reason why the court granted the change of venue. The reason is the facts, the motion with its attachment together with the facts as experienced during the first voir dire. That
until the following April, so now we're 5 or 6 months or 4 or 5 months down the road. Why didn't the district court do a questionnaire like it had done for the first trial and like it did in Pottawatomie County?
What the court was saying about the questionnaire is that doing the questionnaire did not, it exposed the amount of people, or at least most of the people, who had a fixed opinion of the merits and would not be suitable as jurors. But it didn't alleviate the prejudice. It didn't alleviate the problem. It just showed the magnitude of the problem. And the court relied on its experience with the first trial to say sending a questionnaire again will produce the same result. Now, I'd point out, you mentioned...
And then assumes that they were not able to sit an unbiased jury the first time.
The test is it impossible to seat a fair and unbiased jury? The test is there a substantial likelihood?
Was the first trial or the first jury biased?
We don't know that it wasn't, but...
I'm sorry,
that's what I meant to say. We don't know that it was. But again, substantial likelihood. And what the volume of posts in the attachment showed was that, contrast this with cases where the coverage is mostly factual and then abates the further you get out from charge and arrest. This is a situation where the attention...
Where you're talking about abating, but you're relying on evidence that was submitted from November and at an April hearing for a trial that actually doesn't happen for a whole nother year after that.
Posts were in response to the events of the trial. The posts were about, so when trial happens, that spins up again. It does the opposite of abating.
Why my question was there additional evidence that the post did arise again as the trial got closer.
Needed to actually progress towards trial in Cass County, I think, for that to happen. And
Well, they were still in Cass County at that time, right, for a June trial.
right. So I think that, and this is kind of what the court is saying in terms of scheduling trial and having the witnesses prepared and all to get there in Cass County and then discover the thing that it already knew, that it had already experienced, which is that this case is the talk of the town, highly divisive, attention-grabbing, and emotions are hot on all sides. Almost everybody knows someone who's involved or a character witness, and most of these people who are walking into the courthouse for jury service can't serve.
Obligation in a smaller community for the district court to understand that and to make an effort to go ahead and at least get to voir dire or get better evidence as you're getting closer to trial. Given that, I understand they worked very hard on the first day of voir dire to get a jury seated, but they were able to do it. And I mean, there are cases here in Polk County, you might have voir dire for 3, 4, or 5 days on a high profile case. And the judge walks through it and they get it done and they're able to go through enough jurors to get an impartial jury. So why wasn't it an abuse of discretion for the district court not to get more information and at least find out at the time of trial what is the mood of the community?
I think the district court had the information that it needed. It had run this experiment before. And yes, you're right that they seated a jury, but they almost didn't. They almost ran out of potential jurors in that panel to be able to seat a jury at all. And that was a pretty big panel. The idea that I just want to, this is an abuse of discretion review. The same standard, opposing counsel agrees, the same standard applies whether it's the defendant or the state moving for a change of venue.
Stated, but there's underlying, it's the defendant that has the constitutional right to a fair trial and not the state. I mean, everybody wants a fair trial, and therefore, when the defendant makes such a motion, we maybe look at it and are more prone to grant it than we are when the state does, right?
May not have a specific constitutional right, but is also entitled to a fair trial. And I would point out that at the motion hearing, the defense declined to make any argument that a jury drawn from another county would not be a jury of her peers or would not be able to provide a fair trial. They specifically declined.
Mr. Sullivan, one is sort of unfortunate. I mean, we talk about the fact that the only record at the motion for change of venue was one that had been developed right after the trial 6 months earlier. Why did it take 6 months for the motion to be heard? Because, normally, the defendant, if they had filed a written resistance, they would have maybe made a record. There would have been more information. Maybe then the state would have got more information. As I recall, it wasn't even clear whether the defendant was resisting until they got to the hearing. Do you know why this happened?
There wasn't a written resistance filed. I think that it was clear to the parties by the time the hearing happened that the defense was resisting, although the grounds for resisting I don't think were clear up until that point. The reasons for the continuances were related to replacement of counsel, I think, and then an issue with counsel's inability to proceed. The
sequence or timing, there's some questions of your opposing counsel about whether there were, noting the absence of a motion to transfer venue again when it landed in Potawatomi County. But your appellate brief agrees that the defense did preserve error. There was a contested hearing on whether to move it out of Cass County. Did they need to do anything more to keep the issue alive for us?
Yes. I will agree, error is preserved on the issue of was it proper to transfer venue. Error is not preserved on the question of did it err in choosing Potawatomi County? Specifically, page 21 of the motion venue transcript, the court says any reason why I shouldn't transfer to one county over another, and the defense declines. Also, the Court of Appeals points this out in footnote 2, just without the statute citation that you provided, Justice McDonald, that there was no motion after Potawatomi County was ordered as the new venue, no motion, nothing saying there was any problem with that until the motion for new trial.
Case then? I mean, there's a distinction between waiving a claim in the district court, which is what the statute says, and preserving error on this specific ruling, transferring venue in the first instance. It seems like those are different.
Interesting question, because we don't normally see cases in this posture. Usually we're seeing defendants challenging a denial of a motion to change venue because they're the ones who bring it. I think that is an interesting question. It certainly lines up with another interesting question that I think this court might have to forge some new ground on, which is what's the measure of prejudice? That if a change of venue is granted and there was the basis for granting it was close but no cigar, then in what way does the defendant need to establish prejudice? And I think that, characterizing 803.2 sub 3 as being a waiver of the whole claim unless you explain why you're prejudiced by moving to this particular county, that kind of aligns with the idea that we generally expect that a defendant can get a fair trial in any Iowa county unless some reason to think that trial is not fair is proven and established. And so when venue's changed, we don't automatically assume that the resulting trial is unfair or in violation of anybody's rights unless the defense argues and proves a reason to think that. And here they really didn't.
To our review of the district court's abuse of discretion on the original venue change order.
So I think that the law, at least here, is clear that it's an abuse of discretion for the ruling of whether venue should be transferred at all, whether there's a basis for grant a motion to change venue. And that, broad discretion, we defer to the trial court's judgment on the ground. And Robinson says, look, courts, don't ignore the obvious warning signs here. With regards to, I think that if you're going to...
If we were to conclude that the district court did abuse its discretion, are we done? And we reverse?
I see my time's expired, if you allow me. I think there's room for an additional prejudice requirement in recognition of the fact that, even if venue shouldn't have been transferred, there's no reason to think that the subsequent trial was somehow unfair. There's been no showing that this jury was in some way biased, against a person from Cass County or against Ms. Dorsey in particular. And generally, if there is no prejudice to substantial rights, even a ruling that's an error, we usually don't reverse. So I would suggest...
With you, were any of these issues discussed or fleshed out in the new trial motion? Or I don't remember seeing that in your brief either.
To us, it was so clear that this is not an abuse of discretion, that the trial court experienced this voir dire and saw the degree to which, this had polarized the community and made so many people unable to sit and hear evidence and render a verdict, that it found that there's it got by the skin of its teeth the first time on that large panel, but it found a substantial likelihood that next time it might not. And I think that's right.
The evidence issue.
So there's subdural bleeding all throughout the brain, subarachnoid bleeding all throughout the brain, retinoschisis, where the retinas detach and tear. All of these are highly correlated with, in fact, most of the experts say, generally only produced by abusive head injury or a fall from 4 stories up. And there was no report of any sort of accident like that, which rules out accident, leaving only homicide. The defense advocacy, as I understand it, was not that no such trauma was inflicted, only that it had to have been inflicted earlier. But all of the expert testimony that touched on this said there would be no lucid interval with an injury that could produce this, that the baby was able to drink milk that morning, able to do tummy time that morning. None of that would have been possible after the injury was inflicted. So it had to have been inflicted while the baby was in Miss Dorsey's care. She had to have been the one who did it. Thank you.
I'll touch first on the evidence that was presented. I started, the Dr. Smith and Bowen said 2 days was the injury beforehand. Based on the slides, there was capillary and phalanges in the brain that do not happen immediately. The healing process was underway. That was their determination, as well as iron hemosiderin being left behind. That takes time. That is how, the main reasons they decided 2 days was the minimum before, after the injury, before the baby went to the daycare. But the state, their witnesses, Cruz and Hefty, again state that they would not commit to a position that the child must have suffered the fatal injury on that day. They didn't exclude that it could have happened before. And my argument is that with that statement under oath by the doctors, any other opinion would be speculation on their part because it doesn't jive with any other opinion. Dr. Cruz performed the autopsy. Yes.
Transcript, is that testimony that you just cited?
Yes, Dr. Cruz transcript at 6:28, 15 through 6:28, 17, 6:29, through 6:31, 6:31, 6 through 6:32, 12, and 6:52, 15 through 6:53, 08. And I believe that's in our final brief as well, Your Honor. And for Dr. Hefty, transcript at 9:90, 14 through 9:91, 25. The manner of death was undetermined by the autopsy doctor, Dr. Cruz. Homicide's obviously one of the choices she could make. She didn't reach that. Furthermore, Dr. Smith and Bowen, again on behalf of the defense, and Dr. Cadlack from the Children's Hospital on behalf of the state, stated that the child suffered from a blood clotting disorder, DIC, which the defense doctors said could explain the brain bleeding, could explain, therefore, the brain swelling, any retinal issues, retinal bleeding as well. Dr. Hefty stated on her testimony that the results from testing of the autopsy samples alone could not establish that the child died even from a traumatic brain injury. That's at the transcripts 979:06 through 980:24. The lay witnesses, non-experts, are laid out fairly well in the briefs. The defendant cared for 120 children from 2002 to the date of this incident, starting her daycare in 2002. None were ever harmed. Character witnesses that we were allowed to call, there's 6 of them, all from a different perspective, said Allie was, the defendant was peaceful, loving, nonviolent. And the telephone calls that I mentioned earlier really has a narrow window of an opportunity for Ms. Dorsey to do this. The difference between the Davis case, which the state relies on in this case, is not whether there was an injury. Again, it's when did that occur. When you have the state's witnesses agreeing in philosophy with the defendant's witnesses, could have happened before. We believe the standard of substantial evidence is not met, and certainly not the weight of the evidence either. Lastly, in regards to the attachments for the motion for change of venue, if they support Allie, okay, it's not the inflammatory, we argue that, but would it not be any different than the defendant walking in and saying this county attorney that's prosecuting me is an elected office that over half of Cass County registered voters, the jury pool, elected? It'd be absurd for the defendant to raise that issue on a motion for change of venue. And I liken it exactly to this case and the state's argument that, support for a defendant saying to pray for, that sort of thing. The bottom line is the change of venue, the inflammatory nature, such that a fair and impartial jury cannot be had or seated or preserved, was simply not met. I don't even think it was close in this case.
I wanted to discuss that issue of prejudice. I mean, even if we were to assume that the change of venue was an abuse of discretion, usually we don't order another trial unless you can show that there's prejudice. So I wonder what we would look to see that there was prejudice in ordering this to another county.
803.2 is there for a reason. It's so the defendant's rights, to protect the defendant. Moving it to another county is in violation of that, sometimes acceptable under the law. I understand. Number 2, again, it was in the county where 3 of the state's witnesses were practiced medicine. That is prejudicial on its face.
In the record, I take it, that shows an impartial jury misbehavior, anything like that?
We don't have any, interviews of the jury after that one. We do not. Okay. Thank you.
Case of State v. Dorsey is now submitted, and the bailiff may adjourn court.